Red flags that retaliation is already happening include isolation, intimidation, excessive scrutiny, write-ups that are unwarranted, a termination, a demotion, your schedule changes, suddenly you're not offered the same shifts. Those are all signs that you're being retaliated against. Retaliation at work actually means that an employee engaged in some type of protected activity, and then shortly thereafter, they're subjected to adverse action. There's a causal connection between their disclosure and their adverse action, which gives us a signal that this is a retaliation case. Employers can demote or change hours for an employee, but if that employee recently engaged in protected activity, it does allude to the fact that this may be retaliation and not simply a justified business's decision to demote or change hours. Protected activities that employees are legally allowed to engage in could be reporting a workplace injury, reporting discrimination and harassment in the workplace, reporting unsafe working conditions, or illegal conduct like fraud, embezzlement, something they reasonably believe is unlawful employment practices. Common examples of retaliation that an employee may not immediately recognize as retaliation could be isolation, stripped of their job duties, being singled out, targeted, or they could be suddenly subjected to excessive scrutiny, unwarranted disciplinary action, their hours might change, schedule might change, they might lose shifts. Those could be signs of retaliation. Cutting someone's hours, even if they weren't formally demoted, could be a sign of retaliation. Cutting hours affects pay. And if an employer is affecting your pay by cutting your hours, that could be a sign of retaliation. That's adverse action. Employers sometimes retaliate against an employee after they've spoken up because they simply just might not like it. They might not like their employees feeling bold enough to voice their concerns, or they might not believe the employee. They might think the employee is lying. They may say that this employee was already a problem. They already had performance deficiencies, and so it's not related to them speaking up. It's simply they're just not a good fit. Oftentimes, employers try to disguise retaliation with performance issues, restructuring, business decisions, job eliminations, financial decisions, but it could just be an excuse to cover up their retaliatory motives. A sudden change in treatment is very important to show a retaliation complaint. If 1 minute you're a top performer receiving exceptional performance reviews, and then you make a complaint in the workplace, and thereafter, now all of a sudden you're being disciplined, or you get a negative performance review, that's important. So you can go from being praised to being admonished, all like that, simply because you made a complaint. That signals to us that this could be retaliation. Reporting harassment or discrimination does count as protected activity under California law. Employees are protected under California whistleblower statutes from being retaliated against because they reported discrimination or harassment. Retaliation can still happen even if the original complaint was never proven, because once an employee discloses or reports what they reasonably believe is unlawful conduct, they're protected. And so even if that unlawful conduct is not proven to be unlawful, but the employee still reported it, and then shortly thereafter, the employer retaliates against that employee with a demotion or a wrongful termination, it could still be a retaliation claim. Employees are still protected if they make an internal complaint as opposed to filing with a government agency. That's not required. If an employee makes an internal complaint, they're still protected from retaliation if they are reporting what they reasonably believe is unlawful conduct in the workplace. In California, we have the California Whistleblower statute, which protects employees from retaliation in the workplace. We also have the Civil Rights Department that protects employees from retaliation on a basis of reporting discrimination or harassment in the workplace. If someone believes that they are being demoted after reporting a workplace issue, they should question the demotion. They should document what happened to them, and they should either go to HR or talk to management and really dive into the reasons for the demotion to make sure that it wasn't driven by retaliation. If an employee's hours are suddenly cut right after making a complaint, they should start documenting what they're experiencing. First, what they reported, and then what they're experiencing, what they're being subjected to in response to their complaint. If an employee feels like they've been retaliated at work, they should report this in writing. Make a written complaint. You're protected once you do that. Evidence that is important in retaliation cases includes any documentation, whether it's text messages, emails, exchanges with the boss, even diaries, notes. If an employee is documenting in real time what they're experiencing, that helps prove a case when they're subjected to retaliation. Employees should communicate with HR in writing. It's very important to have a complaint in writing so that the employer doesn't argue that it never happened. Oftentimes when it's verbal, it was spoken, the employer is going to say, I didn't know about that. I never heard of that complaint. But if it's in writing, we have solid evidence to support that retaliation claim. Mistakes that employees commonly make after retaliation begins in the workplace is documentation, whether it's a written complaint or notes of what they're experiencing or maintaining those emails, schedules, performance reviews. While you're working, you have access to the documentation. Once you're fired, you typically lose access. So oftentimes the mistake we see is not gathering the evidence in real time. Employees should focus on documentation and not simply confronting management. Get all your ducks in a row, gather your documents, and then once you have the foundation for your retaliation complaint, you can go to someone and make the complaint. But that documentation will help support what you're saying. So that way it's not dismissed or ignored. Proving retaliation at work really involves engaging in a protected activity like making a complaint. You can prove this by having it in writing and then showing that in a short time period, adverse action takes place. So you make a complaint and then there's a causal connection, close proximity of time between the protected activity, like making a complaint, and the adverse action, like a wrongful termination. Evidence that helps establish a claim for retaliation includes emails, text messages, schedules, performance reviews, even disciplinary action like write-ups or a performance improvement plan, a PIP. All of those help us show retaliation and the pretext, the excuse that the employer is going to make to support their business decision to terminate. However, we have other evidence that the employees gathered to show, no, this is retaliation. Timing does play a role in retaliation complaints. If an employee makes a complaint and then years later they're subjected to adverse action, we might not have that causal connection. But if an employee makes a complaint and engages in protected activity, and then shortly thereafter, springing on the heels of that protected activity, the employee is subjected to adverse action like a demotion or a termination, that timing is very important because we want to have that causal connection. Witness statements can help support a retaliation complaint. That is very important because it substantiates what the employee is saying. It shows what they're saying is true and it's supported by other witnesses. If an employee experiences retaliation in the workplace, they should go immediately seek advice from an attorney because there are a statute of limitations in these types of cases. And so it's important to work quickly and understand your rights so that you don't lose that opportunity to pursue a case because of the statute of limitations. I understand that many employees are fearful to speak up because they're scared that they'll be retaliated against if they do. It's a real fear. But if they don't speak up, if they don't advocate for their rights, they're not protected. So what I would say is find the courage, find your voice, tell your story. And if you're retaliated against, if you're a victim of retaliation after speaking up, somebody can help. Talk to a lawyer, get legal advice, but use your voice and tell your story.